Liberty Fighters Network have received a lot of compliments regarding our video that we have posted pertaining to the so-called mandatory vaccination laws that our president are currently considering. And the inevitable question popped up by one of our supporters who asked us, what is the implication of Section 36 of the Constitution of the Republic of South Africa 1996? And henceforward I will just refer to it as the Constitution. Again, I'm going to share information with you that's going to shock you, but it is very important that you know this information and also share it with other people. I've told you before that my late grandfather was a visser and believed that if one wants to do something correctly, one must do it oneself. That is my philosophy too, and in the same sense a bad habit where I find it difficult to trust someone with a task unless I'm sure that person can handle it. LFN's team is small, but I guarantee everyone that we reach for zero defect in everything that we do. It might take longer to accomplish, but we will always complete our task properly. With this in mind, let me clear something first which makes me to question the abilities of someone who claims that he or she knows something about the country's constitution and wants to advise people on it. Since 2005 already, 16 years ago, the Constitution of the Republic of South Africa 1996 is not referred to anymore as Act 108 of 1996. It is only known as the Constitution of the Republic of South Africa 1996 with no reference to an Act number. The reason for that is simple, in that the Constitution is supposed to be our apex act from which all other legislation flows and can therefore not be referenced to with an Act number. Thus, if anyone who wants to advise you on the Constitution writes Act number 108 of 1996 next to it, run away. That is exactly what I do. For brevity, I will only refer to the country's constitution then, as I've said, as the Constitution. So I've noticed that people who are advising us on the Constitution, in template letters, they make reference to the Constitution 108, Act 108 of 1996. And yes, people, unfortunately, that question, I question their abilities. And now, Section 36 is the main reason why our Constitution does not work. This might sound like totally the opposite I've told you in our previous video concerning the mandatory vaccination laws planned. However, when you listen further to what I have to say, it will become clear that mandatory vaccinations laws can never be made in South Africa, and that various parts of the Constitution must be changed, which would take a tedious process of approval through all structures of government and consultation phase with the public, and South Africa have to withdraw from international treaties or agreements. Interesting, even Iraq, when they got rid of the Saddam Hussein regime, their people had a referendum to approve their new constitution. South Africa never had the opportunity to approve our constitution. It was merely accepted by those in power, the ANC government, the National Party at that stage, and also the other political parties in government. The current or the new constitution after the 1993 one, was also rubber stamped by the Constitutional Court, and during that process, none other than our very interesting senior counsel, Advocate Wim Trengove, who was also representing the Minister of Cooperative Governance and Traditional Affairs throughout the lockdown against us, he was the one who was also the counsel for the South African government when the Constitutional Court approved the Constitution, or rubber stamped it. So the legal brains in South Africa were always there, and they were the ones who approved our own constitution, the People's Constitution. Well, now the problem is that when Section 36 is enacted, it means that we need to challenge that change or that conflict with the Bill of Rights ourselves. So we need to go to court, and that act or that legislation that have been enacted stay on our books until the court have declared it as unconstitutional and invalid. However, the Constitutional Court on numerous occasions have specifically judged that when an act or legislation is against the Constitution, it is automatically null and void, and you don't have to adhere to it. You don't have to go to court to get it declared as unconstitutional and invalid. It is unconstitutional and invalid from the creation of it, from the inception date of it. So this is something that you need to understand. And if there is one professor in law that really irritates me, that must be Professor Pierre de Vos from the University of Cape Town. During the national state of disaster, he was regularly called upon to explain Section 36 to the people of South Africa, and was also very vocal to criticize our very own court order, which declared the Disaster Management Act regulations as unconstitutional and invalid. He conveniently never told the people, as a constitutional law expert, that the so-called New Clicks Constitutional Court judgment that we regularly argued resulted in our 2nd of June 2020 court order to have come into operation since 24th of June 2020, meaning that there is no valid DMA regulations in force anymore. Yes, none. After our previous video, people referred to the opinion of Pierre de Vos, in which he apparently again used Section 36 in defending the anticipated mandatory vaccination laws of Cyril. He is part of the Council for the Advancement of the South African Constitution, Casac. Casac was continuously used as a front throughout the national state of disaster, and even intervened as an amicus curiae, a friend of the court, in our very matter, where Advocate Jeff Butlender appeared for Casac and Wim Trengove appeared for the government. Both these senior counsel are also members of Casac. They are in fact colleagues of Pierre de Vos. Prominent legal and other professionals are members of Casac. Now, in this image that I'm showing you, you will see many famous names. The arrows show or refer to very prominent legal experts, and the purple triangles will refer to prominent people of interest. Let me highlight these people of interest. Firstly, Professor Pierre de Vos, he's a professor at the Faculty of Law at the University of Cape Town. He specializes in constitutional law. Mr. Tseliso Tipinyani, he is the CEO of the South African Human Rights Commission. Mr. Sello Hatang, he is the CEO of the Nelson Mandela Foundation. And here I just want to tell you who funds the Nelson Mandela Foundation. Now, number one, it's the Clintons, the old President Clinton, Hillary, and Bill. They fund this foundation. Peggy Dulany and David Rockefeller. Patrice Motsepe, Tokyo Sequali, the Government of India, Vodacom, and the National Lottery Trust as well. Then we have Advocate Jeff Butlender that I've referred to, and also Wim Trengove. And remember that Wim Trengove was involved in the approval of our very own constitution by our constitutional court. He was the counsel in that specific matter. Then, very interesting people, Mrs. Tsepo Motsepe. Who is Mrs. Tsepo Motsepe? She's our First Lady. She is the wife of Cyril Ramaphosa. And then there is Mr. Matatu Tsedu. He was the editor-in-chief of publications such as the Sunday Times and City Press, and was deputy editor of the Star and the Sunday Independent, as well as deputy chief executive of the SABC News. He was a key figure in the creation of the Black Editors Forum, South African National Editors Forum, Southern African Editors Forum, and African Editors Forum. And then the final one, Mrs. Pippa Green. She is the press ombud of the council, the press council in South Africa. People, if you want to know why our complaints against the media is not reaching or reaching the ears of the people that's supposed to, then this might be the problem. Because Casac is sitting around the table and governing our lives at this present moment. Yes, people. Thus, next time when you listen to any interpretation of the law by Pierre de Vos or any of the others on the Casac Advisory Council, remember that they are all pushing the agenda of Cyril Ramaphosa. Let me start to explain Section 36 from the perspective of the layperson, us, the grassroots level people. Section 36 reads as follows, and I want to read this to you. The rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality and freedom, taking into account all relevant factors, including, then there's a couple of factors which I will address soon. Now the key phrase here is law of general application. Now, what is meant with law of general application? Well, that means that the law must be applied equally and must not be arbitrary or aimed at specific individuals. To satisfy the second part of the inquiry, it must be shown that the law of general application is reasonable in an open democratic society based on human dignity, equality and freedom. Again, we refer to the infamous Consolidated Direction by the Minister of Employment and Labour of 11 June 2021. Is this direction a law of general application, Professor Pierre de Vos? The answer is simple no. Because no employer is forced to comply with a mandatory vaccination policy, and nowhere an employer is granted with the authority to limit the rights of the employees. One clearly has a choice to comply to the direction or not, and the alleged policies created are unique to every workplace. Thus, the consolidated direction is not a law of general application, and therefore Section 36 does not apply to it. Let us look at what the criteria is when Section 36 is utilized. The nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and less restrictive means to achieve the purpose. The purpose of Section 36 was supposed to have been to not limit our rights, but to enhance it. Where the majority of the people thus democratically do not subscribe, for example, to the measures imposed by government, the condition that the restriction must be democratic is then not met. If the majority of our people do not want to comply with any restrictive measure imposed by Minister Dlamini Zuma, it implies that government is obliged to accommodate the minority in another way, which does not restrict the rights of the majority. That is democracy. The majority rules. That is meant by the word democratic. When asking if mandatory vaccination laws may be created by government, one must also analyze whether there is a less restrictive means. For example, won't continuing with, for example, mask wearing and social distancing be less intrusive? They have told us all along that mask wearing and social distancing is the remedy. So why do they need to force us to get vaccinated? It's totally ridiculous. Besides, the biggest nail in the coffin for Section 36 to be utilized to create mandatory vaccination laws in South Africa is our subscription to international treaties, or otherwise known as international agreements. I have also referred to international law which does not allow South Africa to have a mandatory vaccination law. When one goes to Section 231 of the Constitution, it reads, 1. The negotiating and signing of all international agreements is the responsibility of the national executive, the cabinet, the president. Then 2, an international agreement binds the republic only after it has been approved by resolution in both the National Assembly and the National Council of Provinces, unless it is an agreement referred to in subsection 3. People, all these agreements are and have been approved by both the National Assembly and the National Council of Provinces. Then this subsection 3 referred to says that an international agreement of technical, administrative, or executive nature, or an agreement which does not require either ratification or accession, entered into by the national executive, binds the Republic without approval by the National Assembly and the National Council of Provinces, but must be tabled in the Assembly and the Council within a reasonable time. Then point 4, any international agreement becomes law in the Republic when it is enacted into law by national legislation, but a self-executing provision of an agreement that has been approved by Parliament is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. The Republic, point 5, the Republic is bound by international agreements which were binding on the Republic when this Constitution took effect. An international agreement, so treaties, for example, treaties like the UNESCO Declaration, the African Charter, etc., etc., they are international agreements. They are multilateral agreements between several countries. You get a multilateral agreement between one and more countries, and then you get a bilateral agreement that's only between two countries. But these are all multilateral agreements, which is, all of them are law in South Africa. Section 232 refers to the so-called customary international law. It says that customary international law is law in the Republic, unless it is inconsistent with the Constitution or an Act of Parliament. Now, what is a customary international law? Customary international law is that source of international law developed through state custom or practice. It is the common law of the international legal system. Now, Section 39 of the Constitution specifically says that, refers to the interpretation of the Bill of Rights. When interpreting the Bill of Rights, a court, tribunal or forum, A, must promote the values that underlie an open and democratic society based on human dignity, equality and freedom, must consider international law and may consider foreign law. So I've dealt with the international law, but the foreign law is, for example, law that is only applicable in certain in a country, or their court verdicts, etc. So you can consider it, but it's not. But you must consider international law. As a result of the fact that South Africa has entered into these international agreements and participated in the customary law, otherwise the common law practices, there is no stipulation contained in our Constitution to support the narrative suggested by Pierre de Vos that South Africa is entitled to follow international law when it suits us. This is basically what Pierre de Vos have been suggesting. Our position is clear further that if Cyril wants to have his say to implement mandatory vaccination laws, the country must first unsubscribe to those multilateral international agreements, otherwise known as treaties, before South Africa may constitutionally implement mandatory vaccination policies. If Cyril proceeds, and he did not change the Constitution first, which would take a very long time, and he must also get all the factions in the ANC aligned on that subject, which is currently impossible, that law will be automatically invalid and of no legal consequence without anyone having to even obtain a declaratory order from the High Court and or the Constitutional Court. Hopefully, I have explained your concerns about the so-called Cyril's dream of having mandatory vaccination laws in South Africa and how he has got a major problem to make it realize. Those who support him is currently in the minority, and you are more than welcome to either accept the majority's will not to subscribe to mandatory vaccinations or find yourself another country where you'd feel safe from all of us unvaccinated who are now treated as if we have leprosy, as referred to in the Bible, and suddenly not welcome where the minority again rules. We are now required to hold vaccination passports to go where we want. This time, those without it are treated different, just like during the years of apartheid. Someone like Pierre de Vos, in fact, implies that this discrimination is fair, merely speaking the will of his fellowship in Casac, above others, our First Lady. I hope that this has clarified the position of Section 36. So the short answer is Section 36 is, according to us, not applicable in establishing so-called mandatory vaccination laws. It cannot happen. We need to unsubscribe to the UNESCO Declaration and to the African Charter above others. We need to break those agreements, and according to the Constitution, as I have showed you, says that those agreements are law in South Africa. It does not make provision that those human rights factors regulated therein are part of the Bill of Rights. It's something separate. It's a separate agreement. It's a separate law that has been created. Thank you very much for listening. If you like this, please subscribe to our channel, ring the bell to get notifications, and also like this video if you really think that it's worth sharing with others. Until next time, God bless.